on the consolidation of these two airlines. And that he published his articles in various economics journals across the country. And then he gets a call from one of Charles Gray's associates. And this is where we start getting into some of the hearsay. And he said he would buy the rights to the publication for $200,000. Is that hearsay? Anyone? Anyone got a guess?
I would say that he's not allowed to use it because there's an NDA involved with the money. So he's agreed to not disclose information about that transaction.
Okay. That's certainly an argument. And that's actually a good argument I didn't think about. One of the issues, I think, with that argument would be that we don't have the NDA. And so it'd be difficult to enforce it without, I don't think we do. I don't think it was an exhibit.
Does an NDA matter in court?
Oh, absolutely. Yeah.
So you can't like testify on something if you signed an NDA on it?
Depends on the situation. Now, the other thing you could argue probably with this situation is, well, he's dead. So one of the parties to the non-disclosure agreement is dead, so it doesn't matter any longer. It's typically used so that you could prevent defamation of character or reputation. So a lot of the every settlement agreement that I do with my clients has what it's not, we don't really call them NDAs, but it has a confidentiality provision within the contract. And it says that you can't say anything. And if you do, then you're in breach of this agreement. Now, what are the damages of that? Who knows? You have to prove it. But I think in this case, I don't think that's going to be a good argument just because we don't have the agreement. So I don't think you can argue there's a breach of the agreement because we don't have it. And Gray's dead too. So I don't think it really matters. I think at the end of the day, it's not hearsay because you don't care whether or not it's true. So you're not using it for the truth of the matter asserted. You don't care if they're actually going to pay $200,000 for the rights. You're just bringing it into evidence to show that there was an offer, that they were interested. Whether they're going to pay him $200,000 or more or less or whatever, doesn't matter to you. You don't care about the truth of it. And then he can testify about what he stated because he's in court. So he can say he said no to this deal. Or that he should have said no, that he did say yes. All right, so then the next paragraph, can he talk about the SEC, the Federal Trade Commission, and DOJ threatening to torpedo the deal? The government backed down. What do you guys think? It's a quiet group tonight. I'm going to say probably not, because the key word in that sentence is right in the middle, suspect, which to me sounds like speculation. I don't think he knows anything about any of that. And he's just some professor who wrote this article. And I don't think he would not have been on the inside of any of those negotiations. So I think if they try to put on this evidence, if the prosecution puts on this evidence, the defense should object and say it calls for speculation and it's a lack of foundation. You haven't shown that this guy was actually in these meetings. All right. At the end of this paragraph, he's again, same kind of thing. He's saying, I cannot fathom the revenue generated to Lannister from the merger, but I have to guess it's in the 11 figures. My 200,000 was looking pretty paltry in comparison. Can't testify to that. It's pure speculation. He has no idea what they made. They could have made $1 on the merger.
Is 41 in like regards to like 41 million?
Where are you looking?
Are you looking on my documents, Ruthie?
Those
Oh,
are
that's the line
numbers.
41. Okay, I got you. Never mind.
Oh, yeah. I guess that has the lines are marked. So what, how much Gray made out of this, how much Lannister made out of this? If you're on the defense, you need to object to that. Calls for speculation, lack of foundation. Those are the objections. Why lack of foundation? Because he's not involved. He was not on the inside. He has not seen any inside documents as to how much they made. He has no knowledge of that, and there's been no testimony that he has knowledge of that, or no documentary evidence that he has knowledge of that. So therefore, you can't talk about it or give an opinion.
So he wrote a paper though on it, and he wrote a publishable research paper on that topic. So would that not make him an expert on that specific merger?
Well, he didn't write a paper on how much money the company made after the merger, right? So he's not an expert on how much money. He's trying to say he's guessing they must have made something in the 11 figures. There's just no way. You can't talk about that unless he knows and he can prove that there's a reason why he knows. It's all speculation. So the next paragraph though is, now before we get on the next paragraph, one thing you might want to do, and this is with a lot of things, if you so say that's not relevant, it shouldn't come in, he's speculating, but maybe as the defense attorney you want that to come in, right? Because you want to get to his state of mind. Okay, so maybe you go at it by saying you thought they made a lot of money on this deal, right? That's what you were thinking. And you were just getting a little tiny piece of it. Isn't that how you thought of it? And then if the objection is speculation or hearsay, you say, I'm just trying to get to the state of mind. That takes away the hearsay objection. And I'm trying to go to motive, right? Because you're going to say this guy is the guy who committed murder. All right, so the next paragraph is really the heart. Hey, can you turn that off or change it or something? It's just echoing. Go somewhere else. You were doing fine somewhere else. All right, so the next paragraph is really the heart of it. It talks about the letter, that he sends a letter to Gray threatening him to take him to court if he did not pay him more. And we have a copy of this letter. So on the defense side, you're going to want to say this guy is enraged because he didn't get what he thought he was should have been getting out of this deal. He thinks they're making a bunch of money, and he's getting a little $200,000. And so we look at the letter, and the first sentence just gives him away again. You have taken advantage of me. And it's all kinds of threats in here. And what he's learned. So the letter, I think, the letter itself is hearsay because it's an out-of-court statement asserted for the truth of the matter, okay? But it also has hearsay within it because he says, now I've come to learn. Well, how's he learned things? He's come to learn things from other sources, other people telling him. I think the prosecution might have a hard time getting in this letter, but I think the defense may want to put it in just to show. This is one of those situations where you might have objections, but you don't object. You want the letter to come in because it shows this guy is very angry, and he wants to do great harm to Gray, and that helps your client because they're saying your client's the one that killed Gray. So I think the letter's probably going to come in just because the defense, even though they have objections to it, would probably want it to come in to show motive. And you could also say it's not hearsay because you're going in to show motive, potentially. And then the response by Charles Gray, which is the next page. You guys think that comes in? Anna, what do you think? Jaden, what do you think? Anna, you there? Jaden, what do you think?
I mean, I'm not, because since Gray isn't in could it, I don't know if it could come in.
I think you're right. I think it's hearsay again. Gray is not in court. But then we have to go back to our exceptions.
What are we not letting into court? I'm confused.
Gray's letter response.
Where's it at?
It's the page. It's an exhibit.
Oh, okay.
I'm sorry.
Sorry.
That's all right. We were looking at the letter by
I
Professor Chartreuse to Gray, and then Gray sends a letter back.
I'm with you.
Okay, so let's look. One of the exceptions in hearsay is if the declarant is not available. He's not available because he's dead. So we look at the exceptions under if somebody's not available. Is it former testimony? No. Is it statement under the belief of imminent death? No. Is it a statement against his interest? No, I don't think it's a statement against his interest. Statement of personal or family history? No. Statement offered against a party that wrongfully caused the declarant's unavailability? No. So I don't think it fits into any of the exceptions. I think that letter is out of the case. And so I think when the prosecution tries to introduce this letter into evidence, you object and say it's hearsay. And maybe the page notes will come up with some answer to that, but I just went through the exceptions and I'm not finding it.
How do we know that it's hearsay?
Because it's an out-of-court statement used to prove the truth of the matter asserted.
Wait, so
So it's
804.
hearsay that it happened, but the piece of evidence like that it exists itself is not hearsay.
Want to have someone testify about the fact that the letter exists? Is that what you're asking?
Like someone wrote this, like Charles Gray wrote this letter, like that's not hearsay.
Right. I think Chartreuse can say, Dr. Gray responded to me. But as soon as somebody says, well, what did he say? Then
Okay.
you object and it's hearsay because that's an out-of-court statement used to prove the truth of the matter asserted. And I think the page notes maybe will come up with some theory, but I bet you it's pretty weak as to how to get it in. We'll see. Maybe I'm
Wait.
wrong.
Isn't it a hearsay exception because of Rule 804, like the cannot be present or testify at the trial hearing because of death? So Graves is an exception because of he's absent because of death.
Right, that was the one I just went through. So 804 says if the declarant is unavailable, right? So then you keep going and you got 804B 1, 2, 3, 4, 5, 6. Those are the ones I just went through.
But if you look at A4,
Okay.
it says cannot be present or testify at the trial or hearing because of death. So it's an exception.
Right. So that puts him into the unavailable. That puts them into these exceptions. Okay. So let's say he was alive. All right. So if he was alive, then if you turn the next page, none of these exceptions would apply to get you out of the hearsay rule. But since he's dead, these exceptions do apply. But the problem is when you go through these exceptions, that letter doesn't fit into any of those exceptions. Right? Because it's not former testimony, not a statement under belief of imminent death. It's not a statement against interest. It's not a statement of personal or family history. It's not a statement offered against a party that wrongfully caused the declarant's unavailability. Now, I guess maybe they could try to fit it in under that by saying Chartreuse is the one who murdered. But
isn't
man,
correspondence like personal history though? Because it's like letters between the witness and it, so wouldn't that be considered a personal history though?
No. Personal history is like your family history. Like you say, Bob was my uncle, and then you die, and you go back and you say, well, how are we going to find out who his uncle was? Well, he said Bob was his uncle. Then you can bring that into evidence. See what I'm saying?
Okay.
We'll see when we get the page notes if they come up with a way to get it in. Right now, I don't see any. These exceptions apply, but I don't think that letter fits into one of those exceptions. All right, so let's go on. He's home alone with his cats when he receives the invitation in the mail. What about what the invitation says? I think it probably comes in because we don't really care about the truth of what it's saying. We just care that he received an invitation. Then he receives his package, and he said, this handwritten note in the package. Bring this to the dinner party at Gray's Mansion. Trust me, you'll need it. No signature, no name on it, no indication whatsoever as to who sent it. Does the note, or him testifying about that note, does that come into evidence? Can he get on the stand and say, I received a note that said...
I mean, since it's like him talking about what he experienced, I think he can, but he can't like talk about like who he thinks sent it or anything like that.
So he's gonna, I think he's talking about everything up until then, up till this part where he says, this is what the note said. Because now at that point, he's talking about a statement out of court, right?
Yeah.
And we don't even know
okay.
who made this statement.
Yeah.
So the reason for the hearsay rule is because evidence that is not trustworthy should not come into evidence. And that's exactly what this is. We don't know who said it. We don't know why they said it. We don't know anything about it. So he should not be able to testify. This statement, this note said this. Now, again, I think with a lot of the hearsay in this case, you're going to argue on the other side, well, it doesn't matter if this is true. What we're trying to show by putting this statement in is his state of mind and how he was going to react to this. What was he going to do? Was he going to bring a revolver? And it shows his motives as to why he brought a revolver. So you would say in the prosecution, look, they're going to talk about he's a bad guy, he's bringing this revolver to the party. Well, this provides a reason why he brought the revolver. And it shows his state of mind at the time. Just doesn't matter if it's true or false. It's not really a true or false kind of statement. It's just saying, bring the revolver. Okay, so you guys got both the sides of the argument there? I think the next paragraph really kind of gives you the clue as to everything you need to know about Professor Chartreuse. You know, why would he show up to a dinner party hosted by someone he hates, and bring a gun to that party? I mean, only with an intention to kill, right? If you're on the defense side, that's what you would say. If you're on the prosecution side, you say, all of that's a red herring. None of it matters. The victim wasn't shot, although we don't know if the victim was hit with the handle of a gun, right? The handle of a revolver, blunt force trauma, right? So those are all arguments for and against. So he has the intention of giving the gun to Gray. I think he can talk about that because it's his intention. I think it's his state of mind. What about this statement? He says to the butler, if something happens tonight, you must have done it, as a wisecrack. Any reason you want to get that statement in on either side? I really don't know. I'm asking you guys.
I feel like it could be seen as like character evidence towards like the witness's outlook on like the trial itself. Like it makes him seem like he's not taking it seriously.
Yeah, here he is going over to this guy's house, and he's angry at him, and he's got a gun with him. And why is he joking about the butler doing something? Something happens. What do you mean something happens? So yeah, I think his whole attitude about everything. And what about, I think it's important here to get in the billiard room, snooker and pool tables, because that could become important later. I think there's a difference in opinion between some of the witnesses about what kind of tables are in there.
What's a snooker?
I don't know. I'm not a rich billionaire. Does anybody know? I guess it's some sort of table game. Snooker? You know what that is? No, yeah. There it is.
Isn't it just like British billiards?
What's the difference between billiards and
Okay,
pool?
so Brett, are you a billionaire? How did you know that?
Okay, Frankie, Brett called me a plebeian for not crushing my own tea leaves.
No, I just remember like because like I called my uncle's billiards room. Like he has a billiards room. I called it a billiards room, and he's like, "No, it's a snooker's room. I don't have like it has something to do with like the number of balls or something that's on the physical table."
Yeah, and like if you look here, like you see like a triangle of all red balls. But
looks like a pool table though.
It does. It looks just like it. What was that?
Well, normal
What's the
pool has
difference between
multicolored balls.
Billiards and pool.
Yeah, but they don't have all of the same color. See, look, like you've got 1 through 8 or 2 through 8, 2 through 7.
What's the difference between billiards and pool?
I think billiards is
billiards is the style of game. Pool is a specific like way to play it. Like billiards is like a type of table game played with a cue, and then because you have like different styles of like games you can play on a billiards table other than pool.
So Brett is a rich man?
Yes.
No.
Clearly. He is. He's sent to infiltrate our little pocket of people.
Our hardworking class people. He's infiltrating us.
We love you, Brett.
It's me and the pigeons. Me and the pigeons, both sleeper agents.
All right, so he talks about these gossip articles that he read about the feud between the defendant Crimson and Gray, and that the two hated each other. So this is a critical point, because obviously that testimony would be very helpful to the prosecution. But is that testimony that would come in, that he has read gossip articles and business journals reporting that Crimson and Gray hate each other?
I feel like it could only come in if you could find the specific articles.
Well, even if you find the specific articles, it's a statement out of court asserted for the truth of the matter, right? It's the matter is whether or not they hate each other, and you're trying to put on evidence that they do hate each other. And what is that evidence? That evidence is some article that's outside the courtroom. So it's a statement outside the courtroom asserted for the truth of the matter. So it's hearsay, and it does not come in. And you need to object to it if you're the defendant. There's a lot of stuff in this next page about what Chartreuse was thinking, and I think he can testify about anything that he was thinking, his sense, his impressions, what he observed, he or she observed, with respect to Crimson and private security with them. And he keeps going back to this thing of this loaded gun or this unloaded gun. Well, it's a gun, yeah, but it was unloaded and I didn't know how to use it. Well, if I were on the defense, I would say, well, you're aware of how to hit someone on the head with it, aren't you? Because you understand that's how Mr. Gray died in this case. He was hit with a blunt force, such as a gun. So all this explanation of it was not loaded, I didn't know how to use it, even if it was loaded, doesn't mean anything really to this case, because Mr. Gray wasn't shot.
I agree with that.
Now he overhears Crimson say, "Make sure to pull the plug after the dessert course. You know where the box is." And he says that to his security guard. Is he allowed to testify to that? Because it's an out-of-court statement, right? Somebody else. It's not Chartreuse making the statement. It's Crimson making the statement to his security guard. Amanda, you seem to know this exception pretty well last time. It falls under an exception to the hearsay rule.
Is it personal experience?
Nope. This is one you've used a lot before. It's a party
Admission of guilt.
admission. Not admission of guilt, but a party admission. So it's going to come in. All right, so whoever, have we made witness assignments yet? Yes?
Yes, we
Who is Chartreuse?
um
Are they on this call?
Hang on. I don't remember. Let me look. Okay. Chartreuse is Avery. She's not on this call.
Oh, okay. Well, I could see the person who is Chartreuse really playing up all of this stuff about looking and seeing all these things around the house and how they're gold trimmed and more expensive than my salary and all this kind of stuff. So if you are a lawyer, you would probably want to limit what they say about what Professor Chartreuse says about that. If she's talking about she saw gold trim plates and silverware, that's fine. But to say that they cost more than her salary, that's all speculation. I would object and say it gets into opinions and speculation, lack of foundation.
Yeah.
You have no idea how much they paid for the silverware. Okay, so just watch out for that. I could see a witness, a Chartreuse, really getting into that. That might be a real... So Gray's statements about why they're joining him for the evening. That stuff could all come in because it could go to motive, it could go to state of mind, and it's not necessarily to the truth of the matter asserted, I think. What about the fact that she testifies, because it's Avery, I guess, right? That if it surprised any of the other guests, this pronouncement, their faces did not show it. Did she testify about that? Ruthie, help us out here. Can she say whether another guest says whether or not they are surprised on their face?
I mean, I feel like if she saw it, she can say that she can explain what she saw it look like, but I don't think it can be taken as the fact of the matter.
Does it fall under the impression rule?
No, I think it's not a hearsay. I think she can testify about nobody else reacted. Okay, their faces were the same. Now, whether that face was showing a lack of surprise, I don't think she can get into. You guys see the difference? It's an observation. It's a difference between an observation and an opinion about what that observation means. Chartreuse is a lay witness, even with all this education, expert in economics, okay? But everything else, lay witness, can't testify about opinions. We talked about that with the detective, that maybe the detective could get into some of that because the detective had training with respect to interviewing witnesses. You guys remember that? So, but with this particular witness, she doesn't have that training. So not an expert, can't testify about opinions about whether somebody's surprised or not. So then Crimson blurts out, "You're so arrogant to invite us here. You lecture us on your money. You disgust me, blah, blah, blah." Again, that's an admission. The objection is going to be hearsay. The answer to it is going to be, it's an admission. It comes in. So what about this conversation on the next page with Dakota Forest? So I think we talked about this a little bit before. They're trying to get it in here. Forrest looked both startled and excited. So they're going to try to get around the hearsay rule with the excited utterance exception. But I don't think that's going to apply because excited utterance is more so something crazy is happening and you say out of excitement, you say something. You're in the midst of calling 911 or something like that. Now, you could also say, well, we're not putting these statements about what they got in for the truth of the matter asserted, just trying to show, well, I can't even make that argument. I think it's for the truth of the matter asserted. Whether or not they brought a knife or got a knife, got a revolver, brought the revolver. I guess you could say it goes to motive, but I still think it's hearsay. We'll see what the page notes say, if there's some argument to get around it. So here's the heart of the matter here. And I think if you're doing a direct examination with chartreuse and you're the prosecution, you probably want to diagram and have a timeline potentially to show. And what you would have is this exhibit with the map. Everybody have the map? And then you'd probably mark on it particular time points, references, where everyone was. And at this point, Chartreuse says 8:43, they enter the hallway to use the restroom. And this, of course, differs from the other testimony. And that's when Professor Chartreuse says, I'm pretty sure I saw Crimson going into the conservatory. Obviously, you want to pick apart the pretty sure if you're on the defense. If you're on the prosecution, you just want to mull over that. Like 2 minutes later, so you would mark on here 8:45. Electricity in the house goes out. Everything goes dark. Here's a woman scream. Several doors slam. Tripped and fell on something. Few minutes later, so we might be at 8:48 maybe. Lights come back on. Head is throbbing. Looks up and sees Crimson's guard standing outside the door to the conservatory. And so this part, if I were the prosecution, I would have this map displayed. I'd go through that and I'd say, where did you see? And I'd have the witness point out, or you could, alternatively you circle it and say, is this where you saw? But remember, on direct examination, you're wanting to do just open-ended questions. You want the witness to take over. So you just say, what happened? Where were you? What time was it? That's all you're going to do at this point of the story.
This kind of feels like Among Us.
Yeah.
Did you say those Among Us?
I said, like you're saying, like where did you see it? Where were you?
Yeah. All right, so that's really the heart of the testimony. The body's then found Here's a critical point, I think, on this last page of of the testimony. I don't know who murdered Gray, but I know what I saw and heard. I've heard Crimson talking about pulling the plug a couple hours before the power went out. So, if you're on the defense, you cannot let Professor Chartreuse say that. Because that, again, is an opinion about what pulling the plug means. And you got to object very strenuously if that stuff starts to come in.
Okay.
And you say, objection. He has no idea what that statement meant. It's complete and pure speculation. And it completely lacks foundation. Those two typically go together, those two objections. Lacks foundation and speculation. So keep those tied together. And then the fireplace poker, they talk about that, but not really sure. So you just hit that as not very sure. But that's Chartreuse. Anybody have any questions? Anything you want to point out with respect to Chartreuse that we didn't cover? Pretty important witness.
So remember how I said last week we'd be able to get through more than one at a time?
It's not going to happen.
No, but that's okay. I think this is really important to do. So guys, if you go onto the classroom, you can open up that doc and you'll see all of my notes from Chartreuse. And then I'll just keep adding to this. So the only one that you'll need to go to the other document for is the police officer. So I'll just keep adding on. So Dean, what do you want them working on in the meantime?
Well, do we have specific assignments as far as who's doing a cross, who's doing a direct of who, and that kind of stuff?
No, we don't have that.
Okay. I think just still going through everything and trying to determine if it's for the prosecution or for the defense, and also thinking in your head, is this coming into evidence or is it not coming into evidence? Is there some argument I can make to keep it out of evidence? Is there some argument I would make to keep it in evidence? And you guys are doing really good. I mean, Brett was pointing out all these exceptions, and that's really good. So take a look at your hearsay exceptions again. I'm telling you, hearsay is one of the most difficult legal arguments ever, and it's crazy to put it on students, but it's part of trial, so you have to know it. But that's what I would be working on. Since we don't have assignments yet, we could also. Oh, go ahead.
Oh, sorry. Can you add me as a commenter on that document so that I can move over all of the original annotations you made on
I'm
Scribble?
working on it. I'm adding it.
Okay, cool. Never mind.
How do you see the annotations on that document? Because I'm not seeing any.
I need to change your permissions.
Okay.
So give me just a second here. My computer's trying to catch up. So Dean, would it be helpful if we make those decisions now about who's going to be doing what?
I think it would. Yeah, it probably would.
Okay. So guys, I'll be emailing you this week and we can figure that out together as a team. Because it's getting to the point where we need to start making sure that everybody is on the call so that we can have conversations with that. Hang on.
The quicker we can start doing some actual, practice, direct exams, cross-examinations, And especially with the folks who have done this last year, I think we can start doing that very quickly, hopefully. And that will help everyone. It's one of those things, trial is one of those things, when you see it, then you're like, oh, that's what you're talking about.
Yeah.
It's hard to learn it with somebody just telling you all about it. It's a lot easier to learn if you're actually witnessing it or seeing it.
So guys, refresh that document and see if you can get into it now. And then what I've got shared on the screen is what our roles are. So, me and I left my folder at school, so I don't have specifically how the breakdown is with 4 lawyers. So we have an opener and a closer.
Right.
And then we have the direct. Oh, I didn't write my witnesses down. Who are our witnesses for the prosecution?
We have Jalen Curry.
Okay.
And we have Professor Landry Chartreuse.
Okay.
And then Arizona Waddleworth, who's the butler.
And then a cross-examination.
Bye, Amanda.
Oh, bye, Amanda.
Hi. Who are the other witnesses for?
The
Who are the
defense,
witnesses? Yeah.
it's Jamie Olive,
Okay.
Reese Warren,
Okay.
and Dakota Forrest.
So, we want our strongest attorney doing the closing, correct? Isn't that what we
Yes.
talked about last year?
Do the opening and closing have to be the same person?
No, they're supposed to be different.
Different.
Okay.
Set up. So I definitely think that for the prosecutor, or for the defense, Brett needs to be our closer.
Can I do closing again?
Who said that?
So Ruthie.
Who do you want as your opener? Dean, do you have?
Would it
Who
be
did
okay
it
if
last year?
Oh, sorry.
I did it last year, but I think Mahadi wants to do it this year.
I would put Mahadi there.
Okay, and then for, I can't remember how this works with 4 lawyers.
Yeah, I have to look back at it too.
Okay. I think I would put Molly as our opener. And I definitely want Evan to be one of the other questioners. The other 3, Megan usually comes, so I don't know if
Okay.
maybe she has going on. But we'll say that these 4 are our lead for this particular group. So Evan, do you have a preference? And Brett, do you have a preference on who you question?
No.
I don't have a preference.
Knowing Evan the way I do, I would put him on a cross-examination.
Which one?
What do you want to do, Evan?
I honestly don't care. You can put me on anything. I'll do it.
I think Evan on Chartreuse might be interesting.
Sounds good.
Okay.
Okay, what about okay, what about you, Brett?
I have no preference. I might say cross with the police officer, Jay Curry, might be interesting to do.
So let me pull up the instruction or the directions real quick. Hang on. So that I can look and see like what the actual rules are.
Yeah, I don't have them. They're not in this packet, I don't think.
I'll pull it up. Here we go. I have them. Hang on. I've got to find it now. Where's it at? Okay.
You find it?
Got it. So the first attorney will present the opening statement in either a direct or a cross-examination. So my opener for the prosecution is Mahadi. So Mahadi, do you have a preference on direct or cross-examination? Or do you guys have a thought on what she would be better at?
I honestly prefer direct, but I can also do cross.
Yeah, I think she'd be good at direct.
Yeah, have her do a direct.
Do you care which one? Which character?
I think she'd be good at Waterworth, maybe.
That's what I was thinking.
Could I
Okay.
do Chartreuse?
Yes. The second attorney will conduct one direct examination and one cross-examination. So Jaden, you need to do a cross-examination as well.
I could also do Forest.
Okay. And then the third attorney will conduct one direct and one cross, and then the final attorney will do closing and either a direct or a cross-examination. So Saruthi, what do you want to do?
Can I do a cross?
Yeah, do you have a preference on which one?
I don't know. What do you think I would do good with?
What do you think, Dane?
Either cross or direct. Is that what you're asking?
Who
No,
in
on
cross?
cross-examination, who should she
cross?
Yeah.
Go back to the witnesses again. What was that?
There you
Sorry,
go.
I lost my train of thought.
No, you're fine.
So
It's very
Alan,
annoying.
I would have her cross Warren.
So then, okay, so that's the defense. Then for prosecute or for defense, we have, okay, so that means Evan needs to do a direct.
Okay.
Unless, Dean, you think he would be a good opener.
I don't know.
Are Dean and
like
Evan
no to
related?
me.
I don't think I'd be a good opener for anything.
Are Dean and Evan related?
No.
Okay.
Hey.
Yes. He's my son.
Whoa, I didn't know that.
Yeah. He's very different than me, huh?
Wait, and Amanda's your niece, right?
No.
She said that you were her uncle. Am I going insane?
I am her mother's first cousin.
So, a weird uncle.
I think she calls me uncle, maybe.
Related
Aw.
in some respect.
Yes,
Maybe just to make it easier for us to understand.
probably.
Okay, so Evan, do you have a preference?
No.
Dakota it is. Brett. Oh wait, Brett's gonna do a cross-examination. And then we have Molly. Molly's gonna be a good cross-examiner, I think.
Yeah,
Don't
it
you
should be
guys-
awesome.
Yeah. So then we'll have Megan.
I thought that
Wait.
the open and closer has to do like the opposite.
So the closer
I
has
think
to
that's
be,
how it has to work out
Yeah.
because you have to have two people do both, and then you have three
Right.
of each. So you have to have the opener do one and the closer do the opposite.
yeah. Oh, you're right. Okay, you're right. So we're gonna put Molly up here. And then we'll put Megan down here. So let's make sure that's clear. So Molly and Molly, Brett and Brett, Megan and Megan, Evan
Wait,
and
can Molly do two if she's opening? Oh, wait, no, never mind.
she's only doing one. Okay. So this is also shared with you guys, and it's also on the Google Classroom. So now that we have that figured out, Dean, what do you want to tell them?
Well, I would read. Has everybody read the entire packet?
Mostly.
Okay.
I have.
Saruthi, you sound very much like Evan.
I skimmed through it. Like, I
No.
speed
Okay.
read it through it.
Go through it very detailed fashion. I want you to read the entire packet so you know everything in the packet, all of the facts. Then go to your particular witnesses and think of what you want to do in a broad fashion with that witness. And why don't you guys put together just a few sentences about what you want to do with this particular witness, whether it's a direct or cross, and have that prepared for next week. What am I going to do with this witness? Just in general, forced approach. And then we'll get into the trees after that. We'll go line by line. How am I going to accomplish that task? Okay?
Sound good, guys?
Yeah.
Yes.
And then Anna's on as a witness, so we need Anna to really get to know her character so that she can start helping her side. She's on the defense. So you'll be, yes, Brett. So you'll be instrumental in helping them with that part.
Thank you.
I'll work on getting to know my part better this week.
Perfect. Yes, Jaden.
Do you know who the defense